Welcome, everybody, to another edition of Tuesdays with Turbine Subject to Change. My name is Lee Fatzinger, founder and CEO of Turbine Labs, and I'm joined by my colleague, Michael Ginn, who's in Westchester, New York right now. And it's a stormy day on the East Coast, I think, both for you, Michael, as well as for our guests who we're super excited about today. We've got Wayne Mattis and Richie Glassberg from Safeguard Privacy. And today we're going to be talking about privacy, GDPR, the California Privacy Act, and there is just so much to cover around this topic, leading into today, advertising, how we interact with apps in the web, and now how devices are looking at us as we're fighting a pandemic globally. Wayne, Richie, thank you so much for joining us. Michael, it's good to see you again. And I'm glad all of you are dry. First of all, let's start with that. I've got a sunny day in Colorado with my lawn guy right outside, who's not like sweeping up trees, but you guys don't have the same weather, do you?
No, Lee. In fact, if I look to my right, I can see trees bending over. And if I stepped out front, it's a little bit howling right now. But you know what? We're on live here, so let's rock and roll. So.
I'm glad that everyone is dry and has power and that it stays that way, not just through Tuesdays with Turbine, but for the rest of the day. And this thing just sort of veers off, the coast and everyone's okay. So Michael, will you do me a favor and help me introduce Wayne and Richie? Because we're so lucky to have both of you join us today for this incredible topic we're going to be discussing.
Terrific. Well, first of all, Richie and I go back more than a couple of years. We spent a lot of time at CNN and Turner together. He launched CNN.com. He was one of the key founders of the IAB. And if there's one thing I know about Richie, he's been
What's the IAB, by the way, Michael, just for anybody who doesn't.
The Interactive Advertising Bureau.
Okay.
And he's always been at the forefront of, the digital, space. And if Richie's involved with something, it's usually important. It tends to impact companies large and small. So Richie, why don't you kind of, introduce what you're doing right now, bring Wayne into the party, and, Lee and I will get out of the way for a little bit.
Just for a little bit, though, Rich, you don't try and take up with, I've seen your LinkedIn profile. There's all these accomplishments, and you can just highlight the big ones. You don't have to go through everything.
So, it's fine. I appreciate it, Lee. Look, we started this company in January of 2018. So, Michael gave the overview. I've been in digital for 25 years. Wayne, I'm not a lawyer and I never played one on TV. Wayne is one of the most famous privacy lawyers in the world and has got a resume that's, twice as good as mine. But our original idea, as Michael was saying 2.5 years ago, was when GDPR came out, and Wayne really dealt with GDPR prior to joining me, we felt that these privacy laws were going to proliferate and they were going to cause issues in the ad tech, martech, and in the entire marketing continuum in the world. And we felt that they would proliferate greatly. And this was prior to CCPA when I convinced Wayne to join me and we started the company. And our belief was that if you look at the last 10 years of programmatic, advertising forgot the consumer and it just went in the other direction. And it really kind of abused the consumers. And GDPR was the first blow back to defend the consumer out there. And now we have CCPA and we believe we're going to have a whole slew of other privacy laws. And we built this company to help companies manage their efforts around privacy. We really feel we wanted to take the sand out of the gears, and nobody was looking at this problem from the industry's perspective. And how do we deal with each other? And how do we deal with the massive amounts of data that's being traded back and forth? And that was, Michael, 2.5 years ago, we said, this is going to be a big problem. And Wayne and I were like, let's solve this big problem. And that's why we built Safeguard Privacy.
Wayne, from an attorney's perspective, I'm going to dive right in. I'd love to get just a little bit of a background, but I would also like for you to give our audience the sense of, we get all these acronyms. We hear GDPR, we hear CCPA, and all of the sort of overarching protections that consumer groups and privacy groups and governments are grappling with as it relates to privacy. So I think it would be, you could just give us a little bit of of your esteemed background, as well as just a quick a summary of the big moving pieces as it relates to privacy right now.
I'll deal with the big moving pieces. Back in 1995, the Europeans enacted a charter, effectively constitutional type rights for the European Union, that included a right to privacy as a fundamental right, something that is not in the US Constitution. And as a consequence, the GDPR, which was enacted 2 years ago, was a logical outgrowth. It codified the rules that Europeans, residents of Europe, mean to have as their relationship with each other and business. And it's broader than the consumer type legislation you see in the United States today. It's fundamental rights that affect everything having to do with them. And quite candidly, it has its origins in what happened in Nazi Germany and the use of personal information there. That's the privacy movement qua Europe. In the United States, the privacy movement is a little bit different. It started out most recently in California, a referendum, a man named Taggart put it on the ballot. In California, you have the ability to have propositions. You can avoid the entire legislative process and just go directly to the voters if you have enough signatures for a ballot initiative. And as a consequence,
they've done a lot of things with that, not just related to privacy.
Absolutely. And he decided he was going to do privacy. And privacy is extremely popular in California. And for people who want to put this in a little bit of perspective, almost everybody has had some of their personal information hacked. I've gotten lots of privacy notices, breaches notices. And California was the first state to enact legislation that dealt with that. Every other state has now dealt with that, and the US government has failed because Democrats and Republicans can't agree on what they're going to eat for lunch, let alone national privacy legislation. And so California did the data breach law, went through the country. Now California has done a privacy law. And one would reasonably anticipate that the rest of the states will ultimately fall in line, because that has been our history. And the likelihood of the US government reacting, you can get people on either side of this debate. I think it's going to be the same thing as with regard to privacy. People remember in his first speech, winning his second election, Obama called upon Congress to pass a nationwide data breach law. It didn't. So, what are you going to see here? You're going to see a lot more of these privacy laws. And quite frankly, I think it's a good subject to talk about, not only because Nevada's already passed one and Washington State came close, but you have a Proposition 24 in California now, where you're going to see even a further iteration of privacy rights. So, that's where I think we can focus a little bit of conversation, because it affects, it affects the advertising ecosystem substantially, and the new law is even going to have greater effects.
I mean, Lee, we've got 14 states with a privacy law in committee. I mean, this is going to be a patchwork of legislation, as Wayne said, and this is going to affect any company that has data on a consumer.
Right.
I mean, this is massive. People don't realize the implications this is going to have. Once you have, as Wayne said, once you have 10, 14 states, you've got a database of your emails for your customers. California's the 5th largest economy in the world. Got a lot of customers in California, Lee. And then you've got Nevada. Nevada defines PII different from California. Then you could have New Jersey, Illinois, Washington State. As a marketer, as a business that captures data on a consumer,
So PII is personally identifiable information, right? Okay, so let's take that as sort of the one of the components of this. And the United States is unique in that legislation it can be patchwork. I think about internet sales tax rates, right? Or things where companies are trying to figure out where can I send products to one place and charge tax and not have another one. And so for businesses, you can see that that's onerous and everything's online. So it's not like I have to put a thing in a truck and move it from one place to the next.
Let me try and help you here.
Yeah, right. I need a lot of help, Wayne. So,
well, let's just stay with the area where I can help you, which is fine. I'll leave the rest of your problems to other people.
Oh, okay. I didn't know that this wasn't a therapy session. Okay, we're sticking with privacy. That's okay. Good. That's probably for the best. Okay.
Yeah, considering my life.
People messaging me over here saying, "Don't talk about your problems." So we're good.
All right, we're good. Two things I think are important for people to understand U.S. privacy law. Number one, it tends to be industry based. We can call it sectoral if you want to. That's a fancier word. But by industry-based, you have HIPAA for the health industry. You have the Federal Trade Commission for unfair business practices. You have other regulations that deal with biometrics. It tends to deal with areas. It's not omnibus, all right? It'll deal COPA, for example, for children. And you tend to be able to know which regulations apply to you based upon what business session you're in. That's the U.S. framework until California came along. Because California became omnibus consumers. And it wasn't one area or another area, it was all consumers. But if you look at the United States, you see that it tends to be sectoral, and it tends to be limited to those areas. They're not broad rights. Those are probably the easiest conceptual ways of your looking at U.S. privacy.
So when you take a look at these 14 different states that all have pending legislation in some stage, how do they mirror one another? These are 14 state legislatures that are saying, the needs of their constituents are different. Florida is not going to behave the same way as Wyoming, I'll assume. So how do they mirror one another, and how does that? I can only imagine that if my internet traffic or some data some PII that I have around somebody, that's going to create a complex labyrinth of issues for my business.
Unfortunately, it is a massive headache. You can just look at the data breach law. The data breach laws have you have to notify all of the different 50 attorney generals. You have really quirky laws, like in New Jersey, you have to notify the local police department. Who's going to know that? Right. You end up having to comply with each law separately. For the most part, the California law is the preeminent framework. But the Washington state bill that came very close to passing, two different versions passed, one in the House, one in their Senate. But they couldn't meet in committee to come to a compromise, which is why it died. But you're going to see one in Washington. It came that close. They're more GDPR-like. But everyone else is very, very similar to California. Nevada did pass. The definition of personal information in Nevada is not identical to California.
Right.
But frankly, the definition of personal information in California is different between the data breach law and the data privacy law. That's not even consistent.
Right.
So we have two kind of themes that we have in our Tuesday seminars. Number one is subject to change. So clearly we're talking about a very fluid marketplace where a lot of things are subject to change. The other thing that we've tried to do was how do you quantify the risk in decision making, both financially and to reputation? And I take a first glance at the fines that are baked into the California laws. It reads like to me the potential financial risk is substantial.
So, Michael, it's worse than you think, right? So Lee and I, we deal with our personal problems and we come up with a new biscuit, Lee and Richie's Biscuits. And we're a small division of a big company. And we hire an agency and we're going to advertise our biscuits. And we want to advertise those to women 25 to 54 that have children in the house, have an income level of this. And you know what? Our distribution's in California. So we're going to buy 25 million impressions on a programmatic exchange in California. So we need location, we need age, we need income, we want them to own a house. These are all standard stuff in advertising, Michael, that you know about.
Yep.
There can be 50 companies between Richie and Lee's Biscuits and advertising that ad on ESPN for Women or Marie Claire or whatever, or Dow Jones or wherever you're going to reach those people. You can buy those 25 million impressions in an hour on any exchange. If one of those 50 players in that string blows the consent string, if the location provider they use, and they may use 2 or 3, and they didn't get consent for that consumer to use that data, you could violate the law. And the way California is written, and I'll let Wayne jump in now, if it's intentional fines, it's $7,500 per individual person. You could blow that by 25 million individual uniques times $7,500.
So I think this is something important. Wayne, I want to hear your response to this, but I think this is really critical. So when I'm on a site like the New York Times, I'm a paying subscriber. I still log into the New York Times, and for some reason, the New York Times likes to present to me ads every single day for Harry's razors. So we're talking about the box that they interrupt my consumption of this story, right? And the New York Times didn't decide that Harry's razors ad was gonna be there. The back end of this is really, really complex to target an older guy with personal problems that says you need a better shave.
But Lee, it's even worse than that. The New York Times, I think other people have written about this publicly, has something like 75 to 100 trackers on their page that aren't even New York Times trackers. There's data companies layering all this stuff on there. Your data is being sucked in all these different places. And before CCPA, there was no need to get consent. Now you need to get consent.
Yeah, but if I had to get to consent for all 50 of those trackers, I'd never read the story.
Well, that's a problem, isn't it, Lee?
All right. So let's now go to the law for a minute.
Yeah.
Okay. First of all, in Europe, consent has to be explicit and in advance and limited. They are a consent in advance jurisdiction, what you would call, in shorthand, opt-in.
Okay.
California has become what is known as opt-out. You can opt out from the sale of your information. The advertising industry has taken the position that sharing your personal information, such as the New York Times might with an advertiser, is not a sale. California Attorney General hasn't agreed with that position. It's up in the air and due for some form of judicial resolution, no doubt, at some point. The new California law, which is likely to be passed, and I can explain why, defines sharing inclusive of selling. It says both of them give you a right to opt out, and it provides that you should have that right to opt out on your browser.
Okay.
So that when you logged into the New York Times, you would put, I choose to opt out from all trackers, and all 100 and some on of those would have to then be turned off.
Now, there's some other people that are taking other actions. Apple at their Worldwide Developer Conference a few weeks ago, announced that the new iOS 14, which is coming out in September, is going to stop that blanket. In the past, when you took an app down from the App Store, you were automatically blanketed in. Now, they're going to start in September. This is their proposal with iOS 14. Every app on your phone is going to pop up and say, can I track for this, 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 this? It is roiling the industry because there's an entire ecosystem that is based on this blanket opt-in. But now Apple is saying, no, we're a privacy company. We believe in privacy, and we're going to make you choose for everyone. And nobody knows what the opt-in rates are going to be.
So, Rich, and when you talk about an industry that's being in turmoil, and then I want to start to get to some of the business aspects of this, not just for, company like an ad agency or a software company like Turbine Labs, but just every business. But how big of a dollar value, I won't call it a problem, but what is the size of the market that we're talking about where one of the two privacy laws, whether it's CCPA or GDPR, is impacting commerce? Like, how many dollars are we talking about here?
You want my honest answer? All 200 billion of advertising in the United States.
Yeah, that's not a small number.
I apologize for not knowing the total market.
No. You're basically saying it encompasses all that is digital advertising.
At least Michael, what's the last number for the IAB? 70 billion in internet advertising?
Yeah.
Not just the privacy laws. Google is deprecating the third-party cookie over the next 2 years.
Yeah.
That means that little cookie, that little file of code goes away. So now you need an identifier. So people have been, and I don't mean to get technical for your audience, but in the last 10 years, people have been doing something called scraping the bid stream. So in all this programmatic, they're just looking at what's happening in the bid stream and they're catching all these identifiers. All that gets caught up in, as Wayne so eloquently puts it, you gotta opt out, you gotta opt in. And GDPR is one, and CCPA is the other, because it was a free-for-all. You could just take that data. Most of the location companies were just scraping lat long. It wasn't right. Look, I'm on this with a T-Mobile hotspot. Shout out T-Mobile, product placement. But it looks like I'm in Texas because that's where the hotspot. So the location guys thought I was in Texas.
Yeah.
They were just taking the data. Now, the third-party cookie going away, this is much bigger. This is the entire industry. The IAB in February announced this thing, Project Rearc. They're trying to this is them, the industry representing the publishers, trying to re-architect identity. And on the other hand, you've got Google over here saying, nope, I'm just deprecating this third-party cookie. You've got Apple over here saying, nope, we're on the other side of the divide here. We're going to say you got to opt into everything. There's a lot of big people making plays here that I think one of the unintended consequences of these privacy laws is that the big moated walls are going to get bigger and bigger because Google knows everything about you no matter what, and Apple owns the operating system. And I don't think that was one of the intentions of any of these laws, to be frank with you.
So if the moat gets bigger and more secure, and I don't think that anyone is surprised after having seen the testimony last week, the Zoom testimony of the big tech CEOs from Amazon, Apple, Google, Facebook, that there is a perception that the moats are already pretty strong. And so you've got one company, Apple, that's saying, hey, we've got an approach to this that aligns with, an opt-in. And then we've got another big company, Google. At the end of the day, for the consumer, doesn't that just mean that it's going to get worse?
Well, it depends on what worse means. All right.
Okay. So that's a great question. So either that the user experience is going to change, but neither Apple or Google want that to happen. It's going to be even more of a sleight of hand of how you get somebody's personal information because big tech is effectively, defining these standards, or you could argue with me that they're not. So there's going to be an impact on consumers, and there's going to be an impact on business. We know that the impact on business is non-compliance and penalties for not adhering to the law, and those, if you want to discuss that for a second, are extraordinary. They're just unfathomable. You'd have every single company in the country bankrupt from penalties for this thing, Richie, because of how you discussed. Like, you could have one cog in the wheel that's bad, and it wrecks the whole thing.
Can we let's backtrack a little bit.
Sure.
All right. The United States has traditionally been a country where what we've wanted for consumers is disclosure. We put on labels when you buy chopped meat, the fat content. When you go buy something, we want to know how much salt it has, how much sugar it has. Its disclosure is in the nature of what we consider fair business practices.
Okay.
And so what something like the California law seeks to do, as it exists now, is it seeks to add that to the consumer marketing stream. It basically is trying, not very effectively, but it's trying for you to know, when I download this app, when I turn on this page, this is the information people are going to see and know about me. You know, when you walk into a department store, people look at you and they can make judgments about you as to, well, this is someone I might be able to sell a shirt to based upon how they're dressed. This is someone who looks like they have enough money to buy a watch. Well, people do that based upon the magazine sites that you look at. And they can tell what, you know, if you're buying a sporting magazine, you might be a good target for selling some tickets to a sporting event whenever we have sporting events with tickets again. But, you know, the point is the point of the law. It's not to prevent advertisers from advertising.
Okay.
It's to let you choose. There are advantages to letting people know what you like. There is an advantage in not getting advertising that's completely uninteresting to you. There is a more positive experience,
Of course,
to not seeing things that are completely irrelevant to you. And Google has done a fairly decent job of trying to explain that, at least, to the American public. The question is simply fairness. What one has to be concerned about is you always have in this life action and reaction. And will the reaction be an overreaction?
of course.
Are we going to get to the point where now the advertiser cannot reach its intended market because the intended market is hidden behind some brick wall? And that's not good for the people behind the brick wall or the advertisers. The unfortunate thing is we haven't seen a meaningful dialogue between consumer rights groups and advertisers and some form of a meaningful compromise. And so, you know, the new California law, let's take an example of what the new law will have contained in it. It's called Proposition 24. The polling shows that Californians are 81% in favor of this. And what effect
That's
will
an
this have?
extraordinarily high number of people that are in favor of that, considering
Really high.
the makeup of California.
This
Really?
tells people where I am. It lives with me. And when I go into a department store, it knows I'm in that department store. So what does the new California law propose? It proposed that it cannot tell my location except within 1/3 of a mile. It can square off 250 acres, and it can say, I am in those 250 acres. That's not going to help ExxonMobil know that I went to its gas station,
Right.
or Shell know who went to the ExxonMobil station so that they can try to advertise me to convince me to switch my gasoline preference. It's going to change that particular part of geolocation business greatly. Michael, you were involved in this area yourself.
Yes,
It would
I
take
was.
good business and it would knock it out. 100% knock out the business that you had.
The easiest way to tell all your listeners is when you finish this call, if you're on Chrome, go to the right-hand corner and click on those three dots. Go down to cookies. Clear your cookies. Clear all your cookies. See what your experience is like.
Well, that might actually do not necessarily listen to Richie, because that experience might not be a pleasant one for you.
You're going to lose.
Well, I think that's his point.
Hold on.
When I see ads,
but Lee, I think there's an opportunity there. I think, take the 4.
If you want to see if your head's going to hurt, get a hammer and hit your head with it. Richie, don't recommend that to people.
Take the four big, Amazon, Facebook, Google, and those guys out of this. I think there's a tremendous opportunity in these privacy laws. I think there's a tremendous opportunity for the New York Times to stand up and say, we're going to be the foremost publisher to protect your privacy. You're going to have choices what we do with it. We're going to be fully transparent with everything we do with it. And we're only going to use what you allow us to use and how we use, and we're not going to. And I think there is a huge marketing potential for everybody else to say what they're going to do with the consumer's data, because you get a lot of value from the New York Times. And as Wayne said, there is value to advertising. So I think we become more transparent. And I love Wayne's analogy of the labeling, right? We got it on all the food we eat and everything we do. So now let's just put that kind of nutritional labeling on all of the websites you go to and all the advertising you get.
Richie, you hit on a couple of key points that I don't want us to lose there. I mean, first of all, the whole concept with cookies, I don't think most consumers understand it. I mean, from what I understand, when cookies are originally developed, it was to help in the e-commerce perspective, so you didn't have to autofill every time you went back to a site to buy something. So there was an incredible convenience that was built into the original use of cookies. But now when I hear marketers talk about a cookieless world when they don't have the richness of targeting data, they revert to, well, I guess I'll have to rely more on Facebook and other walled gardens. And the other thing that I think sometimes gets lost in all this is all of us consumers made a value exchange to get something that we perceive to be free. And, and reclaiming that value as our own right is going to come with a little pain.
Right. So, Michael, you bring up something very important, we got so deep into privacy we skipped this. There are two types of cookies. There's first-party cookies and third-party cookies.
And when we talk about cookies, just make sure that we're talking about a small piece of code that is placed, because I can hear my kids outside the door here thinking that there's something about it's a small piece of code on a browser that's designed to personalize an experience that you have. And so that at the most basic level, it's that, but it is. Yeah.
So let me give you the basics. If you log into your bank account after the first time when you authenticate, there is a first-party cookie that you agreed to because you're a customer of that bank and they authenticated you. So that when you come back, your data is there, right? Or if you shop at Amazon, I'm a huge Amazon guy. Amazon's got a first-party cookie because I'm a customer of Amazon, so they keep my credit cards, they keep my preferences. Those are first-party cookies. Nobody's talking about those. That is when you have a one-to-one relationship with something.
The website, the vendor of the website. Yep, great.
And, nobody's arguing about those. We're talking about the third-party cookies, which are tracking cookies, which you did not agree to. You did not necessarily agree.
Richie, one qualifier there. One qualifier. And I'm not going to single out Amazon because I don't know that Amazon is guilty of this. Sometimes some people who take first-party cookies share them or sell the information without your knowledge.
Right. And but Wayne, isn't that what these laws are now going to fix?
Well, all that I'm trying to do, Richie, is say there are 3 flavors, not 2.
But
there is, I gave somebody my data and they're using it for the purpose for which I intentionally gave it to them.
Yep.
We call that good. There is, I give somebody my data for one purpose and they're using it for another. We call that not as good. And there's, I didn't know that somebody snuck into my computer and inserted a little piece of code and now is following me as I'm walking around the street. and I consider that to be really not good. Okay, there's a 3 flavors.
So Lee and Michael, your name of this, subject to change. There you go.
Right. So
Right.
and I understand at its core the contract that we have with the internet, right? I understand that the New York Times has to sell advertising to stay in business. I understand that Facebook is allowed to or is enabled to deliver a service that I either choose to use or not choose to use because they sell advertising. So and I also appreciate very much the convenience of when I log into my bank account that I can log in again and it doesn't ask me every single time, are you at a public computer?
Right.
What has changed for me personally is the following part, and I think consumers are seeing this, and they don't understand why it's happening. They understand that it's there's almost this spiritual thing out there, or ghost that says we were talking about razors at dinner last night, and all of a sudden I'm seeing razor ads on my on my computer, on my mobile device. That's happening too much to be coincidental. I don't think all devices are listening in that way, but it certainly is. If I look at an Instagram post that's sponsored and I don't even click on it, and then I go to another browser and I see ads for that thing, that there is a connection on the third-party cookies and the sale into this giant web of information about me.
Well, understand that we are limiting our discussion now really to the use of this information to sell you goods.
Mm-hmm.
You understand that there are governments, our own, the Chinese, and others,
Sure,
that are also tapping into this information for purposes we might not appreciate, like your sexual preference, your medical history for whether you're going to be getting insurance or not, whether we should view you as a security risk or not,
mm-hmm.
let you fly on an airplane or not. There are all sorts of reasons that one might not be comfortable that all of this particular bits of information are floating around out there freely in the wild. Because if it's on your computer, it may have been put there by some third party for their purpose, but the Chinese can go grab it too, and so can the U.S. government or anyone else for that matter. And it's the real issue of everyone out there.
Right. The problem got bigger here when the app economy exploded.
Yeah.
You have on average 250 apps on your phone. You have no idea the data collection policies on those because you just downloaded the app and say, I agree to use. They didn't have to pre-GDPR, pre-this, tell you all the things they were doing. And, we can't call people out here, but Michael and I know companies that were in the location business that were doing one thing, and they were basically selling location because your app was telling you where you were. And they got caught eventually, but these apps have a tremendous amount of information that you don't know they're collecting.
I mean, let's talk about the horribles for a minute.
Yeah.
And I'm not saying that the Pokemon app was used for this purpose, but I'm using it as an example of a horrible. There's a database out there that shows where all these kids tend to go, what their habits are, what their locations, where they are at the point in time. You got a lot of kids who are abducted in this country.
Well, that's a great transition in a couple different things. I want to get back to the EU for a second, but I want to talk about this notion that somebody's PII in location. You'll hear a lot of people when they talk about privacy saying, I have nothing to hide. They can take what I want, and maybe it improves my experience, maybe it doesn't, but it doesn't really apply to me. And there's a publication that's called McSweeney's. It's based out of Oakland, California. And a year ago, they put out one of their issues as a book. And it was a series of essays called The End of Trust. And writers like Edward Snowden and Douglas Rushkoff and a number of privacy experts contributed into this this series of essays that were absolutely fascinating. And what they talked about was the notion that if you're sitting on a computer, that's a relatively new one, you've got fast broadband so that we're not, looking all jumbled up here. You really can't say, with a straight face, it doesn't apply to me, because where it does apply is to kids, journalists, people of color, people in lower socioeconomic areas of the country, that it actually impacts them more than those that claim that it doesn't apply to me because I have nothing to hide.
A black person that's living in a certain zip code at the moment is subject to discrimination, employment, housing, credit, just because someone can grab that data and utilize it. And that's not right.
That's terrifying.
Yeah. Well, did you see the horrible event with the federal judge in New Jersey? And she's calling for, why are federal judges' home addresses easily accessible, not behind even any firewall? That somebody who had a beef shot her son and killed her son and her husband, and her address is publicly available. And I mean, this is a unbelievably tragic, horrible use of the data.
It's not the first example of federal judge.
No, it's not. It's just the last 2 weeks. You're absolutely right, Wayne. There are some terrible things that can happen at the speed of light.
So let's go back to this. Can you explain this legislation called Privacy Shield that happened in the EU? And there's news around this because in the last several weeks, the European courts made the decision to rescind Privacy Shield and then provide safe harbor for a whole bunch of U.S. companies. So,
all right, let's reorganize what you said.
See, I told you I had problems, Wayne. I can't even organize one thought about, complex EU legislation.
The U.S. Chamber of Commerce negotiated Privacy Shield with the Europeans. It was the first attempt at encouraging data flows between Europe under the precursor to the GDPR, basically the privacy framework pre-GDPR, and the United States. And that failed. It was struck down by the same court that struck down what became its replacement, which was Privacy Shield, which was negotiated between the DOJ and the Europeans and allowed for the free flow of consumer data between the two areas. Okay, that's one. An individual lawyer by the name of Schrems decided that he didn't particularly like the fact that Facebook was taking data from European citizens, moving it, I say citizens, it's residents, not just citizens, residents.
Okay, sure.
Moving it to the United States and then targeting advertising based upon that data, and that he thought that Facebook should be keeping its data in Europe because it violated European law on several bases. And the two that were successful were, number one, data in the U.S. is subject to fairly unmitigated U.S. government surveillance. The Europeans have determined that that's true. Personal opinion, I think it's true too. We see FISA warrants are just granted without really deep analysis. 702s are granted without deep analysis. And the Europeans say, gee, any data that we send over here, the U.S. government can look at. We don't like it. They don't have the type of judicial supervision that you have in Europe where you need to go to a judge first. By the way, I don't necessarily believe that the Europeans treat their data any differently than we do. But that's a different discussion. They made the decision that the data wasn't safe from surveillance in the United States, number one. And number two, that Europeans do not have the ability to get effective remedies in courts if something is done poorly, badly, violating the GDPR with their data in the United States. And on these two bases, the Privacy Shield was knocked down. And the Privacy Shield, by being knocked down, meant that the Privacy Shield itself could not be used as the transfer mechanism between Europe and the United States for the moving of consumer data. There are other mechanisms, but they are not as simple.
So what are the implications, Wayne? Can you help the audience understand?
There are over 5,000 businesses that have relied upon the Privacy Shield. And if you are not going to use the Privacy Shield, the simplest way for you to deal with this is to use standard contractual clauses. They are going to, the problem, of course, is, nothing has an easy answer. The current draft of standard contractual clauses isn't valid either, because it doesn't address the two problems in what people call the Schrems II decision, or the Data Protection Agency of Ireland versus Facebook, which is the title of the case. It doesn't affect the national security problems that are present in the US. It doesn't deal with the fact that a European doesn't have effective redress in the United States. So you're going to have to modify those standard contractual clauses. I happen to have several ideas as to how to do that. We can discuss them, but that itself is a 15-minute conversation. But I do think that the natural gravitation is going to be to businesses using those provisions, or binding corporate rules, which is even more complicated, or, those are really the two primary. There are others, but those are the implications. It's a good way of causing you to have to hire a lawyer.
Yeah.
Oh, you know any?
Yeah.
I know.
Or a team of lawyers.
Or a team of, well, okay. So you just said this contractual component. Is that become part of the user agreement that I never read, but I agree to anytime I use a service or download an app?
We're talking. The answer is yes, but it's more. Facebook moves a lot of data from Europe to the United States.
Sure, they store it there.
Moves a lot of data. The banking community moves a lot of data. They move employee data. They move consumer data. All sorts of data. So it's not just going to be what appears in your web browser. It's also going to be, business to business contracts that exchange consumer data too.
Wow.
Okay, so here's, I need to do this because we got 12 minutes left, and we've talked about a lot of really complicated concepts. First of all, I want to have you tell me, as the CEO of a business, what do you do as a business in this environment to make decisions based on this patchwork framework that we have here for privacy laws, the California law, GDPR, and all we're trying to do is advertise biscuits on the web.
Okay, are you going to give me 5 minutes to tell you 15 things?
No, I think we're going to have a to be continued conversation.
Right.
I think we're just opening this up.
We're going to have at least chapter 2.
Because I have a list.
Let him have a shot. We got 12. He's done it in 5 minutes or less before.
Go for it, Ray.
So I want to.
By the way, this is going to be at a really.
This is a list of things you have to do.
Okay, really high level. The devil's in the details at a high level.
I wish we had the drum roll thing with Jimmy Kimmel.
Countdown clock. Wait, 5 minutes is 5 minutes. Go.
All right. Make sure that you give consumers the right to know the information you collect, share, or sold. If you have a business model, this applies to every business model you have, every computer system that you're building now, every web page that you're building now, to try and make yourself a valid business for 3 years from today, okay? Because otherwise you're going to be reinventing it. Number one, make sure consumers have this right to know. Make sure they have the right to delete their personal information.
I'm making notes.
Okay? Make sure they have the right to opt out from the sale of that information.
Sure.
Make sure that you are really going way overboard on protecting the rights of minors, because it's only going to get more difficult. And make sure that you don't discriminate against the consumer because they're exercising their rights. Those are the 5 things you had best do tomorrow afternoon.
That didn't take 5 minutes. Wayne.
Now, stop relying on geolocation because you're going to have a problem. Same thing with biometric data. These things are not popular with the public, and there are going to be laws that are going to prevent you from doing that.
And there aren't any department stores left anyway.
Yeah, they're all going bankrupt.
The consumer has more sensitivity about personal types of information than other types of information.
And geo is one of them.
If you have financial information, healthcare information, racial, ethnic origin, sexual orientation, be really careful about how you're using that because that's going to be scrutinized. Stop making automated decision makings based upon racial background that affect employment, housing, credit, politics. Automated decision making is going to be disfavored. Make sure that you let a consumer opt out not just from the sale of information, but you're sharing information. Data brokers, beware. You know, the world is beginning to start to target you. And make sure when you're dealing with behavioral advertising that you're very careful. If a consumer has opted out from you, don't think that that means you can go to your friend, the data broker across the street, and now target them because somebody else collected that data. The law is going to close that little loophole. Personal information, if you ask somebody for information, you use it and you no longer need it, you better be prepared to throw it away. Or if you have a new purpose for it, you better be prepared to say, hey, by the way, we have your wonderful data. You did it because you bought a fishing rod. Would you like us to continue to send you information about more fishing rods? And by the way, we also have wonderful vacation places for you. Would you like to hear about them too?
Right.
Okay.
Right. I just am tired of all the advertising that I get after I purchase the product. Like, you just sold it to me. Why did you just dispirit?
I'm telling you where the law is going.
Yeah.
The law is going to start construing consent very strictly. If I consent to give you data, that doesn't mean for all reasons, for all purposes, and for all time.
And for my cousins and family members and colleagues and
Lee, as a CEO, know where your data is stored, know how your data is stored, know who's storing your data, control your data, know who your counterparties are. You're responsible. Make sure that you know that you're dealing with good actors throughout that whole string. It's very important.
By the way, I'm going to play a game here. Ready? I reclaim my time.
Oh, that's great. So granted.
Okay, and make sure you start protecting passwords as well as security questions and email addresses, because that's going to be considered sensitive personal information too. You know, people have been having data breaches that say, oh, we've only disclosed your password and your mother's maiden name. Well, you know what?
That adds up to a lot of other stuff.
That adds up to an awful lot of other stuff. I did it in under 5 minutes.
Well, that was fantastic. You just did the highlight reel for this hour. I have one issue though, and that is you talked about the importance of not marketing to minors. My 11-year-old came to me a couple of days ago and he said, and I quote, "Dad, I know that you sometimes have conversations with Microsoft. Could you call them and have them reset my Minecraft password because they've deleted my account again?" And I said, "How many times have they deleted your account?" And he said, "About 20. So in that scenario, he's probably saying to Microsoft, who's saying you must be 13 to register for this site, and he's not, but he does anyway. What happens there for a business?
Businesses are going to find more supervision over their failing to take adequate verification steps. And actually, if I should have added another point, it would be verification.
Verification.
The California regulations have gone, I didn't even mention that. California passed a statute, the Attorney General then promulgated regulations. They were anticipated in the statute. In some people's opinion, the regulations have exceeded the statute, and in some cases they have. One area is verification. They've gone into details on verification. The adequacy of the verification of minors has not been enough.
It's nothing. I'm telling you right now, as a parent of an 11 and a 7-year-old, there is absolutely, it's really deplorable. And I can say that, I look at a future business opportunity as coming in and helping a household or a community lock down all of the ways that, things can be sold for minors, because there is no verification.
And so what I'm suggesting to you is the law is going to change, because what I'm seeing is a lot of people are like you, and they're sick and tired of it. And if they can't get businesses to change their practices by begging, then they're going to get their legislatures to change their practices with fines.
Okay, so listen, before we wrap up, I've got to do this, because you guys have come together with a tremendous amount of experience, and both in the advertising worlds and in the privacy world, and tell us what Safeguard Privacy does for companies, and you sort of, who do you serve and what do you do?
So we built a management platform to help companies deal with all these laws. We used Wayne's 25 plus years of privacy experience and his last 9 years at a huge global bank, getting him GDPR compliant. Literally do three things for a company. We assess where you are. We basically have the most comprehensive assessments in the world, and they're to the laws, not to a framework. So they're action items to the laws. So that becomes your gap analysis. Then we literally wrote a whole nother set of products. We actually we give you the yes answers. So we wrote a whole remediation platform to allow you as a company to take all the steps you need to do to be compliant. We literally say, you need to do this. Here's your yes answer to get to yes. We wrote all the training you need for a company. We wrote policies and policy wizards to help people do this. We did things like build reporting so that you can actually see where you are as a company and show your C-suite and show everybody in your company. We did all the document stores. These laws are incredibly prescribed as to the documents you have to keep, and it's very complicated, and people don't realize that in the GDPR, you have to keep 24 plus different places of documents, 15 different places. And then we anticipated a cascade and patchwork of laws. So kind of like TurboTax helps you as a business do every state, the business version. We actually linked all of the laws and the questions, and everything we wrote is original content in plain English. So everybody in your organization can do it. It's not just the lawyers, because the lawyers need help understanding the business, and we linked them all together. So
I'm now going to play lawyer, and I'm going to just say it in the following fashion.
Great. With 30 seconds to go.
We have spent almost an hour talking about the complexities of the law. And if you wanted to go about doing all of this immediately, you would flounder and drown.
Absolutely.
So what we've done is we've simplified it.
Great.
We've taken the law, the statutes, and we've written them so that a person with a college education can understand them. And then we've divided it up into simple steps so that you can start with what's essential, because that's what's going to get you in the most trouble the earliest. We then tell you what you have to do next, and we then tell you what you have to do after that. Compliance is a journey. It's not something that can be done overnight.
Right.
And someone generally needs to guide you to go through it. And we do it not just in a simple way, but a way that's a lot less expensive than spending $1,000 an hour plus having somebody sitting in your offices gathering up the information and helping.
Well, Wayne and Richie, I have to tell you, I'm terrified. I'm still confused, but I feel like I'm a little smarter on this. But I have to say the complexity of this is, and again, it's not like insurance or tax. It's, it's layered because it's all on the web, and it's so hard to track. And I think the next step is we've got to figure out how to get consumers aware of what's happening with their data. But in the time that we have, I can't tell you how much I appreciate you spending an hour, both of you, with us, talking about this incredibly important topic. And to you and to Michael, you're all on the East Coast. Be safe and be well. Stay dry. Don't go outside. And Michael, we'll be talking to you very soon. But thank you again, Richie and Wayne, very much for joining us on Tuesdays with Turbine. And we'll look forward to seeing you all next week. Thanks so much for joining us.
Thank you.
Having us.
Happy Tuesday.
And to you.